These are some most important questions asked in topic High Court, asked in UPSC IAS Prelims and repeated in other exams also such as CDS, CAPF, BPSC. First question, find the incorrect statement. After retirement, a High Court judge, this was asked in 1985, can plead in the same High Court, cannot plead in the same High Court, can plead in the Supreme Court, can plead in any of the High Courts. So these all three statements are correct. He cannot plead in the same High Court. So answer will be A. You have to find incorrect statement. Next, asked in 1992. Which of the following statements regarding judiciary in India are correct? Supreme Court of India is free from the control and influence of legislature and executive. This is true. Subordinate courts are at the head of the judicial hierarchy of the state. No. High Court is at the head. The Chief Justice and other judges of the High Court are appointed by the Governor in consultation with the Chief Justice of India. No. President appoints the Chief Justice of High Court. A High Court can withdraw a case from a subordinate court and can deal with the cases itself if it is satisfied that the case involves a substantial point of constitutional law. This is true. Answer is C, 1 and 4. Next, asked in 2007. Consider the following statements. The mode of removal of a judge of a High Court in India is same as that of removal of a judge of the Supreme Court. Correct. After retirement from the office, a permanent judge of a High Court cannot plead or act in any court or before any authority of India. You see, this question was repeated from 1985. So after retirement from the office, a permanent judge of a High Court cannot plead in the same court, but he can plead before Supreme Court or any other High Court. So this statement is not true. Answer will be 1 only. Next, assertion reasoning asked in 2006. In India, every state has a High Court in its territory. Not true. The Constitution of India provides a High Court in each state. This is correct. Every state has a High Court but not necessarily in its territory. Focus on the word. So answer will be A is false but R is true. Next, asked in 2006. Consider the following statements. A person who has held office as a permanent judge of a High Court cannot plead or act in any court or before any authority in India except of the Supreme Court. Again, a repeated question. He can plead in other High Courts in which he was not a judge. So this statement is not correct. A person is not qualified for the appointment as a judge of a High Court in India unless he has for at least 5 years held a judicial office in the territory of India. Article 217 says that at least 10 years is required. So this statement is also not correct. Answer will be neither 1 nor 2. Next, asked in 2009. Consider the following statements. The Advocate General of a state in India is appointed by the President of India upon the recommendation of the Governor of the concerned state. As provided in Civil Procedure Code, High Courts have original, appellate and advisory jurisdiction at the state level. So both the statements are not correct. Answer will be neither 1 nor 2. This question was also asked in CDS 2019. Next, with reference to the Constitution of India, consider the following statements asked in 2019. No High Court shall have the jurisdiction to declare any central law to be constitutionally invalid. An amendment to the Constitution of India cannot be called into question by the Supreme Court of India. This is not true. Supreme Court has the power of judicial review, so it can question, and High Courts have the jurisdiction to question central laws if they are unconstitutional. So answer will be neither 1 nor 2. Do solve the previous year questions, they get repeated, and questions from UPSC IAS Prelims are asked in different exams. If you want to solve all questions from 1979 till 2023, there is a compilation, link will be in the description, you can buy from there. Subscribe to the channel. Thanks for watching.